Yeah, yeah, yeah. So this is gonna be like a busman's holiday here for me, because I only practice federal in federal court.
So this is overwhelming, all the stuff. Yeah. Well, welcome to the employment law update sponsored by the Lake Zurich Area Chamber of Commerce. I want to thank Claire and Vic for helping coordinate this. We're doing it at the District 95 school, so we thank them for having us here. So part of the seminar today, I do have some handouts, and I'm going to go over all of it, kind of not addressing every point. It's overwhelming enough without me trying to go over every point. The scary part for employers in Illinois is that there are 91 laws that affect businesses. Now, not all of them are for small businesses, but in one of my handouts, I'm going to go over the most important ones that I think that it's good for you to know about. It is hard for me to keep up on the employment laws, and I'm actually going to a legal seminar this afternoon by a lawyer, okay, so that I know how to advise my clients in all things HR. So my suggestion is don't get overwhelmed by the quantity of information I'm giving you. That's why I'm giving you handouts. You can take it back, and look it over later. I just wanted to cover some of the points that I thought it would be most important for me to have you guys know about when you left. So before I start with the handouts, I just want to cover a couple general HR law things. And let me introduce myself. Almost forgot to introduce myself. I'm Leslie Day, Day HR Consulting, and I've helped small and middle-sized companies with day-to-day, general, all of it, HR, for many years. And I also teach at DePaul University. I've taught not the students, the professional HR managers, vice presidents, whatever, for our certification course. And so I've done that for 22 years. So what that requires is that I have to not only know about my small clients, but I also have to know about large employers, the differences. Small businesses are not run like big businesses. That's not something I think that you would aspire to run like Microsoft. No, small businesses have a lot of benefits for being small, having a relationship with their employees, and then the burden is they don't have a lawyer like Microsoft or a whole bunch of lawyers. It's hard to juggle everything that you guys do every day. So that's my point for some of the things I'm going to talk about right now. So it's important to realize that it's very hard to Google HR questions because there's federal laws, okay? Federal laws are overridden by state laws. So that's when the state passes a law that's more generous to the employee. So an example is like the minimum wage. Minimum wage federally is only $7.25 because most states have enacted their own minimum wage. So we're now at $15 at Illinois. And then there's municipal laws that override the state law and the federal law. And so that's like an example for Chicago. So I think their minimum wage now is like $16.80. I can't remember it off the top of my head. So if you just Google something, you don't know if you got the federal law, if you got the state law, if it's a municipality law that applies to you. It's very difficult. So in the handout I've given you, I've actually identified the jurisdictions and the minimum number of employees that you would need to have for a law to apply to you. So if you only have 15 employees or 10 employees and the law only applies for 50 up, then you don't have to worry about it. It's not going to apply to you. But it's always good to know that it doesn't apply to you. An example would be the Family Medical Leave Act. So you probably heard of FMLA. Well, that only applies if you have 50 employees. But a lot of employees think that it applies to everybody. They don't know it's only for companies that are 50 employees or more. So it's important for you to realize that you can discuss that with your employee and say, well, look, that law does not apply to us. We're too small, but here's what we do. Okay. Now let me get my glasses on. The other thing about that's so important is For federal laws, most of the discrimination laws apply if you have 15 employees or more. But Illinois, right during COVID, changed the law in Illinois so that almost all of the laws for discrimination apply even if you have one employee. So the concept of, oh, our business is too small, these laws don't apply to us, is gone. One employee. So I still hear that. That used to be the mantra in decades before. Oh, we're too small, it don't matter. I don't have to worry about all those laws. That got overridden in Illinois. I think it was 2021. Okay. Let me talk about at will. So that is like the most important law we have. And it's a state law. It applies to all states except for Montana. Montana doesn't have at will. They're still a just cause state. So at will overruled just cause. So chances are none of you are just cause employers. You're all at will employers. Okay, so just cause should not be a part of your conversation ever. Okay? So what at will means is that an employee can quit anytime they want. They don't have to give us a reason, and they don't have to give us notice. We'd like 2 weeks, but you know. And we have the same right now, okay? We can have an employee leave without having to give them a detailed reason or any reason, and we don't have to give them notice. There's no requirement for severance. Back when we had just cause, we had to prove to the state. They had a board called the Labor Board that we had to prove to the state that we had the facts that would justify somebody getting terminated. That is gone. There is still a labor board, but it only deals with union employees. So speaking of which, the only employees in Illinois that are just cause are union employees. They have an actual contract. Okay? We have a handbook, which is not a contract. It's just a summary of policies that are in place when the handbook was written. And we can change that whenever we want, and we don't have to notify the employees. We like to update our handbooks every couple years when things change, but we're not stuck with anything that's in the handbook as if it was a contract. If we had a contract, we couldn't change anything until that contract was renewed, like in a union. Okay? So at will is the perhaps most understood law out there. I teach all these HR people, and they still look at me like, what? So at will actually eliminated the probationary period. There's no legal probationary period. There hasn't been one for like 30 years. But we always still like to tell new hires that they have to show us that they can learn and do the job. So sometimes now we call it an introductory period, a training period. We kind of renamed it because it's still so confusing. Some of the lawyers are saying, just take it out, you know. Make sure your supervisors know that there's no introductory period. The interesting thing about probationary periods is that Illinois has a waiting period for coverage for unemployment insurance. So let's say that you have an employee that you have a layoff or you terminate, okay? If you do it within the first 29 working days, so you want to scope out all your new hires real well because you got a month and a half. 29 working days is like a month and 2 weeks, give or take. You have that window of time to determine, is this person going to be successful? Is this what, you know, do they know what they said they know? Is this going to work? And if you decide that that's not going to work within the first 29 working days, your company will not have their taxes raised to pay for their unemployment claim. So whether you know it or not, your business pays not only dollar for dollar when somebody's on unemployment. So somebody's on unemployment, they're on their couch, they get a check, right? A sofa, whichever's the couch sofa. Anyway, I have to have fun. When they're on the sofa, they get a check every week. For every dollar in that check, you're going to have your taxes go up by $1.50. You not only pay 100% of their unemployment check, you pay $1.50, 150% for their unemployment claims. So that's important to realize, that we have 29 working days, but we don't have a probationary period that's a law. That's simply a little exclusionary period for new hires, that we have a window to let them go and not have that coverage. Okay. So what else do I have here about at will? So even though employees are at will and you can let them go if you choose, I've never really had a client ever let somebody go for no reason. There's always a reason, but sometimes it's complicated to go into the details of what it is or have proof, especially if it has to do with theft or something like that. But just because you have the right to let them go doesn't mean that they can't still claim that you discriminated against them or that you didn't pay them legally under the Fair Labor Standards Act. Okay, so it's not like an ole ole ocean free kind of thing. Is that you still have to realize your exposures. So often is it the first 29 days? We worry about that. Then if it's after the first 29 days and we're dealing with wanting to protest an unemployment claim, Illinois unemployment allows you to say, look, I don't want my taxes going up $1.50 because this person stole my stuff or used the F word to my customer, or something that would be clearly a violation of a policy, right? Many times we want to protest those claims. And in order to do that, we have to be able to show what's called misconduct. So that's not like, it looks a little bit like just cause, but it's called misconduct. And so many times when we let somebody go, before we do it, we see if we got all of our stuff lined up. Can we, do we know if we're going to have an unemployment claim that we have to worry about? Could this person allege that they were discriminated against? Has anybody else, that worked for us done the same thing? And did we treat them the same way? Little things like that to worry about before you fire them. There's no window of time that you have to fire somebody. You don't have to do it the day something weird happens. Generally, we like to do it in a week. There's no law, but there's no law. Okay. So I think that's the end of what I was going to talk about for at will. Next, I just want to mention about disability. I spend probably half my time with clients talking about how to handle somebody who's been out. Either they had a personal illness, they had surgery, something like that, where they have a doctor's note. So first of all, an employee is not disabled unless their treating doctor says they're disabled. I can't just go in and say, whoa, I hurt my back this weekend. Can I not do all the hard stuff for the next week while I heal? No, we don't want to fall for that, because now we have treated them like they're disabled and they fall under protection for disability law. We would say, well, gosh, did you go to a doctor? Now, I don't like to refer somebody to a doctor if they haven't gone. I'm thinking, why would I want to send them to get a doctor's slip with possibly a restriction or something like that on it? So the answer is, I'm sorry. You need to do what everybody else does. If you have something, that shows that you have a restriction, let me know. But I don't offer it. I just don't want you to just assume that, so many small businesses are so nice. They're so nice, right? That's why a lot of companies employees like to work for small businesses. And you can totally get yourself into the problem of being nice in the wrong areas and then walking into legal protection for that employee that you didn't realize that you had. I had a doctor I talked to this week, referred by another medical place, and she's had a woman out on, she got pregnant. She started having morning sickness. She's an MP. NP. She's not a doctor, but kind of acts like one at this medical practice. And she hasn't been to work for 2 months. No doctor slip, morning sickness. Okay, I don't know. Maybe, but I would want a doctor to tell me that that's why she doesn't need to be at work for 2 months. Okay, so we have now requested a doctor's slip, and we'll see what we get. So be careful about just wanting to be. This is like the no good deed goes unpunished kind of a scenario. Now, what the law does require for all of you, even one employee, is that if a doctor's note says that Leslie can come back, but she can't lift more than 10 pounds or blah, 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 that we have a legal obligation to see if we can accommodate that. Now that word, accommodate's a legal word. We only use that for workers' comp, injuries, illness return, and pregnancy. We don't use it other places. So if the doctor's note says he or she can't lift for a period of time, we have a legal obligation to sit down with that employee and talk about what maybe they can do, or how can we accommodate this. And that's called the interactive process. It was mandated by law about 15 years ago. We want to document, here's what we thought maybe you could do if you can't lift 10 pounds, for 2 weeks. It's not maybe going to be forever, but it could be forever, right? They have to be able to do the essential functions of their job. So they can't just sit there with their foot up and do nothing. You're not obligated to accommodate that. But I strongly recommend that if you do have a doctor's note, you've got a problem with accommodating whatever that restriction might be, that you call me, you call an employment attorney. Because you're in the seminar, you get free questions, yay! So you can call me for free, right? So that we can make sure you don't by accident think that you can say no. The only way that you can say no to a physician requested restriction is if there's proven to be what's called an undue hardship. Now that's harder than it sounds, okay? My story on that is that there was a company, they had it was a lawsuit, so it was a precedent-setting decision by the courts. They had a woman in a wheelchair who came and applied for an accountant job, and the accounting department was on the second floor of a building, and there's only 2 stories. They did own the building, and they said, "I'm sorry, you can't get up to the second floor. We can't hire you." So she sued. She won, and the courts told the company they had 2 choices. They could either put an elevator in their building, or they could move the whole accounting department to the first floor. So they moved the accounting department to the first floor. So, we're not talking about, that might cost us $1,000. That's an undue hardship. An elevator, okay? So common sense does not really work in HR. Hasn't for a long time, right? So make sure that if you're thinking that you're going to say no to a request for an accommodation, you talk to an employment attorney, talk to me, because you may be walking into an area that you can't get out of. And that it would be just a slam dunk lawsuit if you had assumed that was going to be too big of a problem and you didn't handle the process right. So beware of disability law. And then the last thing I want to talk about is the Illinois paid leave law. So 2 years ago, Illinois passed a law that said that employees, no companies too small, full-time, part-time, all employees in Illinois need to get up to 40 hours of paid leave a year. Part-time people get less. You can have 2 options. You can have it that they get a little bit of it per pay period, or you can give it to them all as a lump at the beginning of the year or July 1st or whenever you do it. And we're having just a whole mess of issues trying to deal with employee attendance problems. So under the law, supposedly, any time off for this 40 hours maximum a year is excused, kind of. Now, we don't really use excused absences anymore. That's also a very antiquated phrase. If somebody's not at work, they're not at work. It's an attendance problem. It's not like I said it was okay. No, I said it was okay that I'm not going to fire you for not coming in, but that doesn't mean it was okay, and it doesn't count for attendance. Right? So we're having troubles like I've got a client who's got an employee who likes to come in an hour tardy. So an hour tardy times 40 hours is that employee can be tardy 40 times a year, 1 hour, and it's excused. What if they came in a half an hour late, right? Then it would be 80 times they could be tardy in a year. So the law, when it was originally enacted 2 years ago, has not had any modifications. So we have not had any clarity as to at what point can we say, what? I can't run my business with you coming in an hour late twice a week or something like that, So please remember that you need to segregate possibly your vacation time if you already had provided paid time. Vacation's separate. You can say we need advance notice. You know, we're going to pay it out at termination. That's another distinction. Give vacation. Paid time off, I've been kind of calling it miscellaneous pay because it could be used for any miscellaneous reason that the employee wants. They are in charge under the state law of those 40 hours. They don't have to tell you why they want to go out. They're supposed to give you notice, but it does say as long as there's a reasonable ability to know you're going to go out. So all the people that do these last minute call-offs are devastating for businesses. And there's no control that we figured out yet on some of that. So I've been trying to work with policies that identify, okay, we're not writing you up for Illinois paid leave, we're writing you up for last minute call-offs. So far that seems to be working, but I'm actually going to an employment law seminar later today, and I'm planning to ask my favorite lawyer, how can we do that? Because it's one thing to give somebody a warning, but if you actually fire somebody for it, we've got to make sure that we have our ducks in a row and that we're not walking into a lawsuit. So that law is too new. We don't have a lot of clarity as to what the courts now are saying you can do or can't do. Nobody wants to be the first lawsuit. We call that the test bunny. Nobody wants to be the test bunny for this law. So I haven't seen any lawsuits about it in the 2 years it's been out there. So I don't exactly know how to advise you for sure on that, but I just want to make sure that you're very clear that you don't use that paid time as part of attendance discipline, okay? That you would realize that that was like a holiday. You're not going to write somebody up for taking a holiday. You're not going to write somebody up for taking paid leave. Hard to absorb when you're dealing with every day having to have people at your organization. Okay, any questions on any of that? I will handle questions at the end of the seminar, of course. So I'd like to next go to the 91 reasons not to fire somebody. Okay. We're not going to do that yet. We're good. So just a quick story. I grew up in Glen Ellen, moved to Virginia I don't know, I was 25. It was right when the Bears went into the Super Bowl. I had just moved. My father said, don't come back because maybe it was you and now the Bears have won, you know. But I then returned right when Blagojevich was elected as governor. And at that time, I had already was a consultant, and I was realizing that there were 24 laws in Virginia, federal laws and state laws, 24. And I got here and there were like 40, 45. And I was like, oh my God, how am I going to manage this? I mean, almost double the laws, right? Well, now we got 91. I used to have them all on one page, okay? Now it's 3 pages long. So there's just been an explosion of employment laws, either new laws or they tweaked a current law to add something in, and it's just overwhelming. If it's overwhelming me, I got to figure that your eyes would be crossed in a heartbeat. So I'm giving this to you so that you have it in your file. I also gave you the slides, so you got it in your file. So you don't have to know all of it. You can take it with you and look at it when you have a question. Okay? So just to explain just a couple things on this, some of this I'm going to also cover on our slides. But go down to the bottom, well, let's say 21. So before the gray, okay? There are 21 protected classes now. Now, when the Equal Employment Opportunity originally made the laws for discrimination in the 60s, there were 6. 21. So what that means, and that's why this is called don't terminate somebody for this reason, what we're saying is that all those reasons cannot be part of an employment decision. They're supposed to be not related to employment. Somebody's race, who cares, right? Their sex, who cares, right? You would not have that be part of a reason for there to be any adverse employment action, which we call in HR firing somebody, demoting somebody, cutting their pay, turning them down for promotion, those kind of things. So these 21 things should be irrelevant to any employment decision. Now, just because somebody is in a protected class, like I'm I'm a woman and I'm old. Okay. So I got 2. Okay. I'm not fully disabled, but sometimes in the morning I think I am, right? So that doesn't mean that I can do willy-nilly whatever I want because I'm in a protected class. It simply means that I can't have an adverse action because I'm a woman. So let's say a company was going to be doing some training and they said, hey, we're not going to have all the old people come to this training because this is costing me $2,000 and they may retire. So I may not get my return on my investment, my ROI, from that training if I have old people come. That would be an example of excluding some folks from an opportunity because of their protected class age. So that would be a risk for employment discrimination claim. This also applies to harassment. Harassment is the most misunderstood word out there, second only to employment at will. So the way harassment works is that the action or the intent or the wording that a person who's harassing somebody has to be about that person they're harassing's protected class. Okay, so if I'm just being a bully and I'm pushing my coworkers around, that's not harassment because it's not about that individual's race, sex, national origin, blah, 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 disability, all these things here, right? So the example I use in class is, let's say I was hired to be a administrative assistant. Okay, not probably my best job. Okay, but anyway, and I'm having a hard time getting the swing of the software and learning the procedures, and they have to keep repeating the instructions to me over and over, and I'm getting real moody about the whole thing. So if my boss is yelling at me, yelling's not illegal. If my boss is yelling at me because I can't remember stuff and I'm not learning and I'm moody, okay, that's not illegal because it's about my work. But if my boss yells at me and says, I can't believe I hired an old woman to do this job, you can't remember squat because you're old, right? You must be having menopause issues because you're all moody, right? Right? Now that yelling is tied to a protected class. See the difference? So if you have an employee at work who is saying unkind things to an employee about anything on this list, that's an exposure for you not only to have a possible claim, but it's also not nice, right? We don't want to have our employees bugging and saying unkind things to their coworkers. So we need to intervene and say, look you can't talk like that here. I use the word bothered a lot because it could be sexual harassment. It could be harassment based on their national origin. It could be about their religion. It could be that they're gay. Who knows? All the things would be an exposure possibility. So you just got to not continue to hire people if they're going to be being, harassing your employees based on their protected class. You may want to think, do you want to lose your business over a claim because somebody is being mean to your other employee or a customer? Okay, there's times when you say, look, we just can't have that person come on our facility anymore, or a service person who comes and fixes your machines, or the delivery person. You have a loading dock. Gosh, the truck drivers, what an exposure that is, right? So you need to monitor to make sure that you don't have one of your employees illegally harassing another person. Now, for it to be illegal harassment, it has to be a big deal. Can't just be one comment. Okay, one comment, like one dirty joke on a Friday when you lost it, does not make illegal harassment. It has to be severe, meaning like somebody pinched somebody in a provocative place. That could be assault, right? So that could also be illegal. But the other word that is for the requirement is that it be pervasive. What a cool word that is. So it's not a couple, it's not a lot, but it's pervasive. So again, that would be the example for the dirty comments or the sexual innuendos or things like that. So we need to realize that we need to monitor that. And if an employee says something to us, we need to take it seriously. Under the law, if an employee comes to you and says, so-and-so's harassing me, if you blow them off, they can go and sue you like the next day, and they'll win because you had an obligation to do two things, okay? A legal obligation to do two things from the Supreme Court. One is you had to do an investigation. You had to go out and go, well, who saw this? What happened? You ask the person that they're alleging it happened to. You know, there's some concern that's been risen about something you might have said. Tell me about blah, 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 blah. Again, witnesses, you try to investigate, right? So you get the whole picture. Then, after you get the information, and you got to write it all down, a formal investigation is when you write people's statements down in general and who, you know, how you thought through what to do. And then you have to then make a decision as to what to do. You got to do something, okay, to preclude it from reoccurring, to preclude reoccurrence. So maybe we're going to have so-and-so go to a different location in the building so they don't see each other all the time. Maybe we're going to fire somebody. There are times with sexual harassment where supervisors and managers are still wanting to have, you know, sexual relationships at work, and we cannot have our supervisors and managers dating or thinking that they can have a sexual relationship with an employee and thinking that it's going to be okay. The legal risk for your business is massive. Okay? So you need to then take steps to preclude reoccurrence. The minimum the lawyers are saying is that there should be a written warning. The minimum. Okay? And that would be kind of like, don't do it anymore. Okay? And here's how we're going to support you not doing it anymore. We're going to move your workspace, or we're going to do certain things like that. Okay? So those are protected classes. Pretty interesting, huh? Then number 27, nobody here's from Chicago, so I'm excluding the Chicago stuff, although it might apply to bigger businesses who have multiple locations. Then retaliation. Retaliation is the most common claim that the federal and state government have, and it's a floater claim. It can attach to any of the other allegations for discrimination. So it could be added on to race discrimination. Not only was I discriminated against, they retaliated against me after I complained. They fired me. Or it could be like, I asked for overtime. I didn't understand why I'm exempt, and I've never been exempt at other jobs. And then suddenly, boom, the person's fired 2 weeks later. That would be an example of retaliation. Retaliation is a time-based concept. So if somebody has a negative employment action, soon after they say, help me, company, I thought I should get overtime, or help me, Mike's bothering me, or any of the things we talked about, if they lose their job or they're not offered a promotion or not involved in training or they get sent to an icky shift, the closer the time frame between those two incidences, the more likely that there will be perceived to be a relationship, that they lost their job because 2 weeks earlier they asked for overtime. Okay, it's about 2 years. About 2 years. Now, the longer away, the more unlikely it is that there's going to be a correlation. But you don't want to just think again that, hey, you know, it's been 6 months, so we're okay to go. The courts have still found that for 2 years to be a correlation. Remember, the courts, you know, they're not indifferent. They are definitely biased towards the employee. The rationale for that is obviously companies have money, they can talk to lawyers, employers are onesies out there. So the government sees themselves as a representative and to a certain extent an advocate for the employees. Okay, talked about retaliation. So I already talked a little bit about the paid sick leave. Ban the box, I just want to mention on number 51, you need to have a legal application form if you are hiring folks in Illinois. Now, if you choose just to take an applicant's resume, that's your risk, because what we say in HR, resumes are fiction, application forms are fact. The person signs it at the bottom. Yes, all this stuff is actual, factual. I didn't fudge any of my info, right? And it also says that if it turns out that they did fudge it, and it was critical for me being considered for the job, that the company can let me go. So there are a lot of times when people are motivated to either escalate their title I hear it a lot. Well, I wasn't really the office manager, but I did all these managerial things for that. I should have been the office manager. Well, what was your actual title? Accounting assistant. Okay, well, that might make a difference. So fudging titles, fudging dates of employment, very, very common. So we do suggest, that National HR Association suggests that you have an application form. So when you get to the point where you're thinking, okay, this is the one I think I want to offer a job to, I suggest that you give them an application. I've got a legal one. It's a Word document. Put your company at the top. Call me, email me, whatever. I'll send it to you. Please use that for your employees. Ban the box is a law that we used to have on the application form. Have I been convicted of a felony? Okay. Well, we can't have that on there anymore. They banned the box that said yes, no. That's the box that they're talking about. Have you ever been convicted of yes, no? Okay. That whole thing can no longer be on your application form. Okay. You can ask about criminal convictions only if you do like a first interview. Also, Illinois has a law that makes it very difficult to do criminal record checks. So if you want to pay to have an outside company verify if somebody has a criminal record, we have again, during COVID, Illinois passed a law that pretty much made it impossible for you to not select an employee because of a criminal record. I think that businesses should decide on their own if they want to have somebody who's got a criminal. But not only did Illinois make it so that, no, we can't really do that. Just about 2-3 months ago, they announced that all misdemeanors were being blocked. What's a word for that? It was like, there you go, expunged. Thank you, Mike. Expunged. So you couldn't find them if you paid a company to do a records check anyway. So in Illinois, if a criminal, somebody who was convicted and paid the price, whatever that was, they are at the end of the time that they paid the price, either jail or whatever, they are golden. That is not appropriate to use in an employment decision. Now, there are a couple little exceptions. Like a bank, okay? You would not want to be a bank. Yeah, well, the DCFS is going to cover yours. Right, so your DCF background check covers that. Yep, that's okay. DCFS, the Department of Child and Family Services, has a process for those involved childcare, schools, they can do it, but not the rest of you. Although Tammy Banks, you don't want to hire somebody who embezzled from their last company. That might be a problem, right? But there is very, very few of these exceptions. So if you're currently doing a criminal record check, I'm just I'm sending them the slides that were created when this law was done during COVID, that the lawyer seminar that I go to all these lawyer seminars, I have to know what's going on. So I have the slides where they said, well, here's what a mess this is. I'm just forwarding those slides to any of my clients who want to do criminal records checks so they can hear it from the lawyer in these slides why this is really, you can pay to have a criminal record check and they can tell you, yeah, this person, was arrested for assaulting somebody in a bar at 2 a.m, but you can't use that to exclude them from employment.
So because we work in homes, I can't check.
That's bonding. So you can do some bonding stuff. Why don't you ask your insurance agent? Right. So that's bonding. Okay. And bonding kind of went away, but I can't understand why everybody that does have visits to people's homes and stuff like that, why they're not using that.
They actually recommended I get an employee theft policy instead. It's much more economical.
Well, that only covers theft. I had a handyman go in and allegedly assault a child.
No, it also covers. I have another one that covers.
Okay, got another one?
Yeah. Or if the person goes and sexually harasses a customer or whatever. Mm-hmm. So it's like it's killing me.
Mm.
All the extra.
Well, that's very smart. That's very smart. There is another policy you guys can get called EPLI, Employment Practice Liability Insurance, and that's probably what you're talking about. And it covers allegations of discrimination, that they weren't paid their overtime properly. And it's a policy that's a rider on your workers' comp claim, your workers' comp policy. So there are some limited areas where you have some insurance that you can get to cover this. Okay.
Just a quick question. When you say DCFS handles that, is that a separate criminal background check?
Right, so every one of your employees should sign a release for DCFS, and you send it to DCFS, they send it back, they go, okay. So they would have verified the criminal background. Now, there's also a separate check that you can do for free, which is the pedophile check. And you can actually do that for free. And you don't have to have a signed release for that, but they do have to sign for the DCFS check.
What about, because like the Lake Zurich Flames, whenever we would do a background check on a coach to make sure, you can't do that anymore, I take it. Even though the coach is not being paid, they're a volunteer.
I actually, for nonprofits and stuff like that, I have a sample policy that I can give you that you would have all the volunteers sign that says, here's the rules. You cannot do this. And one of them is don't mess with kids. You know, you at least want to have something in writing that they sign that said what the rules were, because many places don't have anything for volunteers. Oh, we're so happy you're here, you know, and you're free, you know. No, cover your risk. So I'd be happy to send that to you for the Flames. The policies that you would have for EPLI, you would want to find out if you can have that covering volunteers. But, you know, there's risks, you know, I don't want you guys to get freaked out too much, but there's risks everywhere. It's interesting being me. Okay. But anyway, I just have a couple others I want to talk about. If you got anybody who works 12-hour shifts, and this is 54, last year, year before that, they passed a law that said that, you know, everybody has to have a meal break in Illinois. If they have a shift that's 7.5 hours longer, they have to have an unpaid or paid, doesn't matter, meal break, where they don't do anything. They literally have to be relieved from work. That's actually when the break laws were originally created. That's why companies started having lunch rooms, because people would eat at their desk and then the phone would ring. Oh, now we've blown the meal break. So now they want, get away from your desk. We're going to create a lunchroom in the late 1800s when this was created. So Illinois added to that law and said, okay, now if somebody has a 12-hour shift, they have to have an extra 20-minute break in the middle. Okay, companies are messing that up all over the place. Now, there's times when you don't know that somebody's going to have a 12-hour shift. Let's say that you're behind and it's like, God, we got to get this done, and it's going to be 7 p.m. before they end and they started at 7. Okay, somebody needs to keep an eye on that. So there's a fee for every employee who doesn't get a meal break. And you actually almost have to prove at that point that they got a meal break. So if it's an unpaid meal break, you want to have them clock in and out. If it's a paid meal break, that allows you to keep the employees on site. If it's an unpaid meal break, they can go to Wendy's, they can do whatever they want. Right? But if it's a paid meal break, then you can say, oh, we want you to stay on our facility here. But you want to just try and anticipate so that you don't wind up having, it's like $200 per violation. And if an employee goes to the state, they're going to pull your payroll records. And if your payroll records don't show that employees were having these breaks, how are you going to win? The employees could say whatever they want to say, and now you're having to pay money. So be careful. Okay, what else did I just want to mention here? At the very bottom, 62, we are going to talk about the new requirement for AI. But there was a requirement last year that said that anytime you put a job posting in, whether it's Craigslist or any kind of a job posting on any of the sites, in Illinois, you need to have there be a pay range that's part of the posting that's realistic. You don't want to have it be so big that you never hire anybody on one end. You want to have it so that it's kind of realistic. And then you also have to list your benefits. So if you have a match on your 401k, it's got to say we have a 4% match on our 401k. Our medical insurance, we pay 80%, you pay 20%. You can't just say medical, dental, holidays, paid time off. You got to be specific about it. Okay. So just make sure if you have postings, and I'm going to talk about another posting requirement later on. Okay, let's say 72, everybody needs to have an I-9 form for every one of your employees. That is the only legally mandated form. Employees can say, I'm not filling out that W-4 form. Fine, we put them in for single one in taxes. But the I-9 form is legally mandated, and it requires that the employer know how to fill it out right, that they get the proper documents. We always suggest you make a copy of the documents that are provided. Once you have the right I-9 form, you never get it again from the employee. Okay? It doesn't matter if you keep it in their employee file or not, but the suggestion is to take it out of the employee file in case ICE comes to your facility. You don't want to have to be, given the whole employee file. You want to just provide the I-9s. We're having some issues. It's on the slide, but I'll mention it now. There are folks that are here and born here and they're citizens. Okay, I'm a citizen. Then there are folks that are here for permanent, they can live here permanently and they have a permanent work authorization. Okay? Then there are people that are here temporarily and they have temporary visas. Those are called non-immigrant visas. What we're having, last fall they announced, there might be some delays in our approval for temporary visas. Usually these visas every couple of years, you got to send in $380, something like that, and then they process it, and they say, okay, you can stay another 2 years. And it's been streamlined forever. Now, instead of having it approved usually in a 3-month window, it's 8 to 10 months. So I've got clients who have employees that were brought in when they were children, that's DACA. Other folks that have been working here for years with renewing their temporary visas, and they're not getting renewed on time. Sadly, the law requires that if their visa runs out, you have to fire them. Now, I had really thought maybe you just had them unscheduled, okay? But there's one law that says you gotta actually terminate them. So there are companies that are terminating thousands of employees now who have had their visa come up between October-ish and now, paid their money thinking it was 3 months, and they're not getting renewed, and they're having to be let go. So on the I-9 form is where you find out where that temporary visa expires. You need to always keep track of those. I put on my calendar 2 years ahead. Joe's going to expire, and I tell him 6 months before, okay, you're coming up. You got the $380 or whatever the money is now, because that's usually the story. Oh, I got to send this check in with it. And so that they know that I'm supporting, reminding them. But now, instead of 3 months, it's 8 to 10 months. So they would submit it almost a year before they expire. So we don't know what's going on. But I just want to point that out. If you have some folks that are here on a temporary visa, they have the right to work while they're here on a temporary visa, only until the date that expires. And before, let's say that they didn't send it in time because they didn't have $380. We would just kind of dance with it for a couple of weeks. Well, you actually get a receipt when they send it in. So we can say, okay, you sent it in 2.5 months before it expired. It's probably coming here any day. And I would advise clients, well, here's your risk, which was pretty small. Now the risk is humongous to do that. They're really saying that we need to have to fire folks, which I just am shocked about. Okay. I don't think there's anything necessarily that I need to go over here. I don't want to be too far out of time. If you have any questions on any of these, please email me, call me, okay? Call me makes me happier because you'd have to leave me a message. It says, hey, I was in your seminar, because sometimes I have to ask, how many employees do you have? What counties are you in? Some information about your business in order to give you some advice. Okay. So let's go on to the slides. This is a lot of information, okay? Because there's been this many law changes since last year. So this includes 2025 slides. We had a chamber seminar last September. And those are on here. And then I've updated for the last 6 months for any new stuff. In your copies, the darker shading is the stuff that was this year. Okay? The lighter shading was the stuff that either was effective January 1st or was effective sometime last year. So that's on the slides. Okay. So let's just talk a little bit about discrimination. I'm sure you've heard a lot in the news about DEI, illegal DEI. Of course, it was all a big part of the federal administration change last January. Just to, and I teach this at DePaul, right? So I'm trying to get it down small for everybody, but EEO, Equal Employment Opportunity, is the federal discrimination law. And what that, as an example, means is that let's say you had a posting and you had 100 applicants. So consider that like a pool or a corral or something. And those are all the eligible candidates for you to consider for that hiring. You would not want to have anybody get kicked out of the pool because of their protected class. You don't have the old folks kicked out. You don't have the minorities kicked out. So everybody stays in the pool. That's EEO, Equal Employment Opportunity. The Equal Employment Opportunity Law never says which applicant in the pool to hire. That's up to you guys. Every company gets to decide, and that's called legal employment. We're considering folks based on work-related criteria, how much experience they have, what they're good at. We call it KSAs in HR, knowledge, skills, and abilities, right? How they interview. Do they seem to have good communication skills? Do they have leadership thoughtfulness that would be required for a supervisor, right? All these criteria that are work-related are how you pick out of that corral. Let's say you're going to only pick one person out of that 100. It's up to you to pick. Okay? The law never says who to pick. What happened with this illegal DEI stuff is that there was, especially after George Floyd, there were DEI consultants, and I'm still mad at all of them. I'm just going to tell you, okay? Because this has been a huge black eye in HR. DEI consultants started telling companies that they had to hire specific people in the pool. You had to hire the minority. You have to hire the female. You have to hire the veteran. You have to hire the disabled person. Okay? And there's never been a law that required that, ever. There was some examples that we get in HR where the DEI consultants were blackmailing businesses saying, if you don't hire the minority, we're going to out you on social media. So that clearly then gave a preference for hiring for minorities, females, disabled, and veterans. The folks who lost out of that were the non-protected class people, the white, the young, the male, but all the folks that weren't protected class. And that's where illegal preferences was what is identified in DEI, and that is now being addressed federally. Okay. You've probably heard of affirmative action. Okay. Affirmative action is a part of EEO, a very small part of Equal Employment Opportunity, that only had to do with federal contractors, companies that sold a product or a service that got eventually bought or used by the federal government. So let's say you make a little bulb at your company, and the bulb goes in a headlamp, and a headlamp goes into a car, and the car gets bought by the federal government. Okay, all of the companies that make every part that goes into that car, including my little bulb place, are affirmative action employers. They created, back when Lyndon Johnson was president, Vietnam era, they created affirmative action. What they said is, look, if you're going to get some of the federal money, tax money, you have to have a higher standard for hiring minorities and females than your basic EEO company does. They never said who to hire in the pool, but they said that you're accountable if you don't historically have a more diverse workforce. But there was never a quota or a requirement in any circumstance. It was affirmatively suggested that you go and find more qualified minorities. So we would apply at minority colleges. We would go to the minority engineering clubs. Same thing for females. So we would try to get more qualified candidates in the pool that maybe we could hire. That's what affirmative action is, getting more qualified folks in the pool to expand our ability to maybe see if one of those is going to be who we want to hire. So I hope that helps you understand a little bit about DEI. So there should not be affinity groups is where especially corporations had employees get together exclusively based on maybe their national origin or their religion or something like that. Those are not supposed to be done anymore. And there should not be a preference in employment to any individual. EEO is the law. You guys get to pick. You just wouldn't want to kick anybody out of the pool, right? If you say we're only hiring white males, that would have kicked everybody else out of the pool, right? We're only hiring young people, then all the old people, and it's only 40 or over that's old. If you didn't know it, if you're 40 or over, you're age protected. Half the employees in the US are age protected. At some point that was old when they first passed that law in the 70s. I guess that's not the case anymore. So I think that maybe that helps with some of the information on this slide. The reverse discrimination was this thing about having protected class folks have priority over others. The unintentional discrimination is a really important for us in HR. Companies have been held accountable for a discrimination that they didn't quite figure out they did. It was like unintentional. Like I'm picking Sue and Mike because I'm keeping them in a layoff because they're my best workers. Well, guess what? What if they were both 38 and the two people you lay off are 45? Now all the old people got laid off and maybe you weren't thinking about that. So that's called disparate impact or unintentional discrimination. The federal government says we're not going to pursue claims for that anymore. Hoo-hoo. Hoo-hoo, that is huge for us. So I gave you the explanation for EEO. They just, this month, the federal government said, okay, you can have separate bathrooms based on sex without worrying about transgender conversations. So that was a new one. Okay, next slide, please. Just some general ones. How much time do I have, Vic? Half an hour? Okay. I want to make sure I handle questions and stuff at the end. So this is just kind of it didn't fall into any category. So one of the third one down, AI, I gave you a handout. This is really important. That identified that if you have any job posting, you have to put these words at the end of your job posting identifying how you use AI. Now, a lot of people say, oh, shoot, we don't use AI. But if you use Indeed, ZipRecruiter, LinkedIn, not Craigslist, so some of the smaller ones do not use AI. But they have used Indeed, ZipRecruiter for a decade. So when you have the applicants come up on your screen, they used AI to figure out what you see. How are they prioritized? Do they kick out the person who lives in Colombia who applied? There's AI in that software. That became effective the first of the year, and the lawyers have not told us what to say. Mostly because lawyers don't like to give advice on something they don't even know the answer to. So the state of Illinois created this law, said we have to have that in every job posting. So just think how obvious it is. If it's not there, you're guilty, okay? So as a punt, I created this list that I'm giving to my clients. You see this is not legal advice, okay? Because putting something in that's not perfect in this case, is way better than having nothing. Okay? Even if it's not perfect, you at least followed the law, then there'd have to be an argument about that it wasn't exactly right. So all of your job postings from now on, please put it at the very bottom, okay? It also requires that you're supposed to tell your employees, and we're not even there yet. Maybe, we're gonna have it added into handbooks when they're edited. If a company doesn't have a handbook, we're probably gonna have employees sign something that they were told. But I would imagine almost none of you have a AI screening tool that you use to screen out applicants, right? You look and see who responded, you pick the ones you want, you bring them in. AI didn't decide who to bring in, okay? So that's kind of what we're talking about. But sadly, Indeed, and those do use AI to even show you the responses. Okay? So at the very bottom of your posting, so you're saying, I need this person, here are the job rules, here's the requirements, put it at the very bottom.
So even if you're not
paste it in.
using the filters, and you're saying just give me everybody, are they still using AI behind the scenes?
And if you look at Indeed, type in at Indeed AI, you'll find pages and pages and pages of how they use AI. Now, they do have some software where they will help do, you can have some bot do interview questions for your applicants now. I mean, it's really gotten crazy. So the fact that Illinois passed this law saying, not here in Illinois, when Indeed's it's international, right? Some of these posting sites, it's really become like a what the heck do we do kind of situation. So by posting it, it's not like you're changing anything. I'm just wanting to do a CYA move. And I'm planning on showing it to the lawyer when I go to the thing this afternoon, because it's an HR association meeting, and find out why the heck they haven't told us what to say. What I did in January is I started looking on job sites for like companies that I thought that knew what the hell they were doing. And that's where I got the information from. University of Chicago, medical school, or whatever. I just started accumulating where the very few, and again, there's not a lot of companies even now that have that on there. I just started scarfing wording from folks that I thought had gotten legal advice. Okay. I just want to point out, I highly recommend that you do it even if it's not accurate. The other thing is it does require that there be a contact. Who writes these laws, right? We don't actually say in our job posting, hey, if you haven't heard, give me a call, okay? But I suggest that you create an email. Almost all my clients have an email like resumes. It's just where all the resumes would go to. It's not a public, like it doesn't get dumped into your email box. Create that email and have any questions go to that email with just somebody's first name is my suggestion. It requires all that information in the law that they passed. So that's got me wanting to make sure that you guys know about that. Oops. I need to pass the slides faster, huh, Vic? There's also at the bottom of that a page, the two bottom things on the page, thank you. Illinois actually for the first time in like decades and decades and decades is modifying unemployment law a little bit. And they've decided that if somebody has to leave work because they have a mental health issue and they have a doctor who says that they have to leave work and the company can't accommodate whatever restrictions they have, that they would get unemployment, but we're not charged. Okay, that's cool. So it's a 3-year pilot program. So if that applies, that is something that would be good to know. And then at the very bottom, you got to have posters. You got to have your compliance posters up. So pretty much everybody this year needed to have new posters. Now, there wasn't a change at the federal level for like 4 years. You didn't need new posters every year. You only need it when it changes. So these poster companies are such a ripoff. You know, they say, hey, it's 2026, you need your new posters. Wrong, but now you do, okay? So you need new federal and new state compliance posters. Okay, next one, please, Vic. Okay, I got 2 slides here on pay. Most of you know that as of tax year this year, your employees had the ability to get a tax credit if they received tips or if they worked overtime. Now, most of my clients are not tip type environments, but all my clients had overtime. So if at the end of the year, your pay stub said, here's how many hours of overtime, you were in good shape. But a lot of payroll companies don't even have that as a field. So one of my clients, we had to calculate it all and send everybody a notice so they could do their taxes. The interesting thing is that you know that overtime is 1.5 times their base pay. The tax credit's only on the half, which is a third. So if they worked, you know, $12,000 last year, they only get the tax credit on like 4. No, they don't know that until they do their taxes or they send it in wrong. So I actually had it. So we said, here's your total overtime for last year, and here's the taxable credit amount, 1/3. So I think it's good to know that if you have an employee ask you, I need to know how much overtime I had last year for my taxes, you need to let them know so they can get that tax credit. And then all the payroll companies are now modifying their software so that that is going to be something that is easily identifiable in the future for your employees. Okay. I could talk for a whole hour about the Fair Labor Standards Act and exempt employees. Okay? The Fair Labor Standards Act, it was from the 30s, 1930s, okay? And what it identifies is that jobs are innately non-exempt, like hourly. But if a company wants to identify some jobs as exempted from overtime, they need to follow the government's rules as to which kind of jobs those can be. They can be executives, supervisors, managers have 2 full-time equivalents. They can be professional jobs where, like an engineer, you go to college for 4 years and then you learn how to be an engineer. It doesn't mean that an HR person gets hired and they were a teacher. No, you don't learn how to do HR as a teacher. So it has to be that the job has a 4-year degree that qualified them and has the information from that education so they can do their job. So a professional job, and you would have in your postings, must have a BA in this, okay? Another one is outside sales. So if I have a retail establishment and I have salespeople, those are inside salespeople. Outside salespeople are the ones that are supposed to go outside the office and sell, but now those are all done on the internet. So that whole thing has kind of lost its punch because so many salespeople now are exclusively in an office. So only for outside salespeople. Another one is a little computer exemption. And then there's a catch-all that's for administrative jobs. Now, this has to be such a high-level administrative job that the person makes decisions of significance without asking the boss. So how many administrative people do you know that make decisions of significance without asking the boss? Okay? And we're not talking about, hey, I need more pens, you know, or, you know, no, this has got to be like, oh, we're not going to pay overtime anymore. Or, you know, you can't do that, but, you know, it has to be a very, very high level administrative person. Office manager might qualify, depending on how much they have the ability to make decisions. If it's not those categories, your jobs cannot be exempted from overtime. And there are some jobs that are just a mess that back in the 30s they never thought about, like in, Mike, you might have an estimator. Maybe you're the estimator, who knows? But sometimes in construction, there's estimators that go out and they look at a job and then they're higher level, right? They're kind of salesy, but they're really doing estimator. There's no clarity for that job to be exempted unless you try to say it's outside sales, but that doesn't really work for the government standpoint. So especially with small businesses, we have jobs clumped together, and a lot of business owners think that they can just say you're salary exempt. But if you're doing it and it's not under the parameters that the law gave you, you're illegally excluding those employees from overtime. And you would have to go back and pay that person 2 or 3 years back pay, plus interest and penalty. If you have a bunch of them, you could go out of business. And they don't let you say, oh, can I pay it in a payment plan? No, you got to like make the employees who didn't get that money for a couple years whole at the time that there's a complaint. So in order for a job to be exempted, you have to do that duties test, and it has to be that the individual in that job makes at least $35,000. Now, the Biden administration had a proposal that went in until the year before that, that raised it up to 58,000. 58,000. And that got undone, just like Trump did it to Obama when it got to 35. So there's been a tug of war politically on how much a minimum salary should be for a job to be exempt. Now, 35,000, that's like $16 an hour. Minimum wage is 15. So why in the world, would it be okay to have somebody, right? When somebody be thinking, I'm smart, right? I'm going to have all my people exempt and I don't have to pay overtime. So I'm just always terrified. And almost every time I get a new client, I find some jobs that are down as salaried exempt that don't qualify. Now, how do you tell the employee, hey, now we're going to start paying you overtime? Because the employee then says, okay, but what about last month? And the month before that, and the month before that. It's like a Hotel California. It's hard to get out of. It's hard to get out of. So I wanted to make a really big point about that. And we also just had clarity on independent contractor rules. That has also been a football between administrations. Independent contractors are not employees. They're people who have their own businesses, who have their own skills. They have their own tools. They work when they want to. They don't work when you say. You don't pay them hourly. They would say, hey, I just finished your floor and you owe me $3,000, right? And it gets paid out of accounts payable. They're not employees. They complete a W-9, they're 1099. Okay, that's an independent contractor. So there are times when companies, sometimes in HR we don't even know because it goes through accounting, they bring somebody on to help. Maybe the person's in an unemployment window and they just want to have somebody come in and work for a while, and they say, well, you want to be an independent contractor. Maybe the person says, hey, you can just have me as an independent contractor because then they don't have taxes taken out. The problem is it might not be legal. Same thing, the government has given us criteria for how individuals can be legally not our employee. The government wants all the independent contractors to be employees. Why? Taxes, right? The government gets their taxes right away. They don't have to wait until there's some shenanigans done in April when they do their taxes, right? And employee gets benefits and other things that the government wants, including Social Security contributions, right? So now independent contractors do have to pay their Social Security contributions, but and then of course you would not want to pay somebody cash. That's a bigger risk than an independent contractor. So they were tightening the requirements so that there would be less individuals qualified to be independent contractors under the Biden administration. Now it's been loosened up again. They just announced it last week. What does that mean for you? Is that ask somebody who knows if you have independent contractors to find out if they are legal to be independent contractors. Now, if I have you again, Mike, sorry. Mike has employees. They come and they do your floor. Well, they're an employee of Mike. So that's not an independent contractor we worry about. I get an invoice from Mike saying, hey, we fixed your floor. I'm talking about the individual, the onesie person. I'm an independent contractor, okay? You don't pay me by the hour. I say, hey, I did your handbook, here's the cost. Small cost, okay. Next one. So the government decided that we were not giving enough info on pay stubs, or employees were not getting pay stubs, especially if you have like accounting software that you're using for your payroll. There could be limited information on pay stubs. Even Bamboo HR is one of my favorite payroll softwares, and they didn't have overtime on their pay stub. They're kind of a newer company. I was like, well, come on, overtime? That's kind of important to put on there. But anyway, the state mandated what has to be on pay stubs. And the difficult part was this. So if you have an employee quit or you terminate them, they have to be able to stay and have access to their pay stubs. If you have like a payroll service where they put their password in and they can see their pay stubs and their hours, and we put notices in there and stuff like that. If that is left open through the end of the year, you don't have to do this. But a lot of companies, man, when the person's gone, they cut them off from accessing any of their pay stubs. So the government, that's the government just hears about people who complain, and then they get all busy in Springfield and then, you know, they come up with a law. Not only do we have to make sure that they get their final pay stub, okay, live, if we've cut off their access, we have to give them in writing and say, if you want all your pay stubs for the whole year, let me know. And we have to send them all of them. I don't even know how to get all of them. There's not a report I figured out on how to get all the pay stubs. You have to do it one at a time, okay? So all you have to do is have in writing. So whenever you let somebody go, you know, sometimes you send them a letter saying, hey, we're going to send you your last paycheck next Friday. If you have insurance with us, you know, you're going to get a notice about COBRA. You know, there's almost always some kind of a letter that you would want to send somebody when they're gone. But you now have to put in writing, if you want all of your pay stubs for this year or the last 12 months, let me know.
Even if you hand them a check that's.
Well, if you have, who knows where those things go, right? So it's Friday, where did my pay stub go, right? So if they have access to the software, the thing now to do is don't cut them off. If they have access to the software, don't just cut them off. Let them still have access for the end of the year. But no, they gave no options. If you they don't have access electronically to their pay stubs, like they're going to do their taxes next year and they have to get all their stuff. I think some of it might have had to do with overtime because employees were not able to get their tips and their overtime for their tax credit this year. But yeah, you have to put that in the goodbye letter. And I already had one of my clients get called. Yep, I'd like and the person was just screwing with the company, right? But yeah, so they had to actually email them every pay stub. The stuff that makes me crazy. I also want to mention BIPA. Time clock companies are still selling Illinois employers biometric time clocks, where you put your thumb in, your hand in, they do your eye. They're almost illegal in Illinois. If you do have a time clock like that, you literally have to notify all your employees. The employees can say, no, I don't want to have to put my personal private property scan into your computer. They can say no. And you have to be responsible for managing that confidential information. So like if somebody quits, you have to have a policy that says within 10 days of them quitting, we're deleting their scan. And you have to manage it perfectly. The amount of lawsuits that are out there are lawyers that are making billions of money because companies just aren't getting it. These companies are still selling time clocks. So if you have a biometric time clock, please, please, please call me, okay? And I think I already talked about salary ranges in postings. Okay, Vic, next one, please. Benefits. Now, you might say, oh, we don't have a lot of benefits, so this is probably not going to be a huge one for some of you. They just announced with this Trump account, when the president did his State of the Whatever speech, he announced that they are going to have savers match, where starting in 2027, the government is going to send money right into our employee 401ks. How are they going to do that? No idea. To match employees' contributions up to $2,000. I mean, it is clear that 401ks are not providing the dollars that employees need when they retire. Back, you know, in our parents' era, they had pensions, and people at corporations had them and nobody else did. So it's kind of better than it was like decades and decades ago. Illinois also has the Illinois Secure Choice plan. They've lowered that now to 5 employees. So if you don't have a 401k or an IRA, something like that, you need to enroll at the Illinois Secure Choice website. And what it means is that you have to have ACH so that after-tax money can be taken out of your employee's paycheck and sent to a savings fund that they would have managed by the state of Illinois. Why would I want to have the state of Illinois manage my employees? Well, why don't I just get a 401k or a simple, or, you know, the 401k is a lot more administrative costs than a simple, but talk to a financial person, right? There's almost no reason anymore not to, because they keep lowering the amount to the point where it's a pretty, now you can still do it if you have less than 5, but it's mandated. Yeah. Okay. Okay. There you go. If anybody's going to be going to the wars, wherever they are, you need to make sure that you're aware of that new law, nursing mothers with milk, organ donation, unpaid leave. Some company fired an employee whose wife just had a baby in a neonatal unit. They fired him. So in Springfield, they made a law. No, you cannot fire somebody whose kid is in a new baby is in a neonatal. Okay, immigration real quick. I already talked about the huge delays for this. I don't think that applies. I need you to understand about OSHA. OSHA is a law that if you have a workplace, you have to have a compliant workplace. It's your responsibility. Okay, so those are the penalties. So if there was like not a cover on that outlet, $16,500. Didn't have the sign on the wall that says you are here, $16,500. If you have anything blocking your emergency exit, that rectangular square that says exit, that's above exit doors, anything blocking that, or you have a deadbolt on it, not a push bar, $165,000, right? So please, if you don't know about OSHA, talk to somebody. I can do walkthroughs. I'm not a super OSHA certified person, but I'm marginally certified. And then last, they are about to, in Illinois, pass heat and cold temperature. So anybody who has employees that work outside, work inside an unheated warehouse, they are coming up with some mandated requirement. You know, got to give them water. Okay, sorry. So last, in the future, they're really focusing on religious discrimination. They're going to give us some new W-4s. I already talked about that DEI is going to continue. We in Illinois are the second highest quantity of disability claims in the U.S. That's why I talked about disability. I need for you guys to understand how you can get yourself in doo-doo over that. Okay, that's all I have. I can handle questions after. Please ask me free questions. So please, if you email me, say I was at the seminar, call me, leave me a message. If you get my voicemail, I want to answer your questions. Okay, Claire? Thank you. Thank you for coming.
Does anyone have any questions? Just real quickly, we're talking about the Illinois poster. So I know, like you said before, it was you only needed if they put like an update